Well, you're right on time. It's 1 o'clock, so let's begin the meeting. I'll call the meeting to order in the absence of the chair. The first item of business is, first of all, the first item of business is to say that the chair is absent. And last week, we agreed on, as a general proposition, the permissibility of remote participation in circumstances where regulations permit it. Under 940 CMR 29.105E, geographic distance, which fits the chair's circumstances today, does permit remote participation, and so we'll proceed with your participation by telephone, Mr. Chairman. If at any time you can't hear us, please say so, and periodically we'll talk to you so we can make sure that you hear us.
Okay, great, thank you.
The first item of business is approval of the minutes of June 18 and June 19. I also distributed late Friday the minutes of June 26. I don't know whether everybody's had an opportunity to read them. If not, we'll put approval of those minutes off until next week. Has everybody had a chance to read them, or should we put them off till next week?
I read them.
I read them.
Okay.
I read them also.
Yeah.
Yes.
Commissioner?
Yes.
All right, so we'll then take up the approval of the minutes of June 18, June 19, and June 26. And I'm going to make a motion to approve all three sets of meetings in the fashion in which they're filed. Is there a second to that motion?
I second.
All right. Are there any corrections to the June 18 minutes?
Just one kind of spelling correction on page 2, final paragraph. You talk about the city councilor from Springfield, and councilors are C-I-L-O-R instead of S-E-L-O-R. I want to denigrate your profession, Judge.
No, I understand, or uplift it. All right, I'll make that change. Thank you, Commissioner.
Commissioner McHugh, I couldn't really hear Commissioner Stebbins.
All right, well, that's a warning that we need to keep our voices up, so let's
Right.
use the microphone.
Yeah, Mr. Chairman, it's just a correction on page 2. We spell out the city councilor from Springfield as counselor with a S-E-L-O-R instead of C-I-L-O-R.
Good.
All right, we'll make that correction. Any corrections to the June 19 minutes?
On page 6, Commissioner, the last paragraph in the third line, it's just a typo. It says in having a form as opposed to a form.
All right. We'll make that correction. And any corrections to the June 26 minutes?
I would just say about all of these that this is a lot of work, and they are very good minutes. You don't see very good minutes all that often.
Well, thank you, Mr. Chairman. We start with a good rough draft prepared by our intrepid reporter, and then some editorial work is done, and between the two of us, we have produced the product that you see in front of you, so thank you. So I'm going to then ask for a vote to approve the minutes. Because we have participation remotely, we have to do this by roll call. So first, Commissioner Stebbins, how do you vote on the motion to approve all three sets of minutes?
With corrections, aye.
And Commissioner Cameron?
Aye.
Commissioner Crosby?
Aye.
Commissioner Zuniga?
Aye.
And I join the vote to make it unanimous. All three sets of minutes are approved. The next item of business is the executive search firm update, and for that, we'll turn to Commissioner Zuniga.
Thank you. I submitted a memorandum relative to my recommendation to select and contract with executive search firms. This is after the result of evaluating and the 4 proposals submitted and interviewing with all 4 proponents. My recommendation here is that the commission accept the proposal submitted by jury staff. I have also, by the way, included the evaluation score sheets as part of the packet. Jury staff is the ranked highest with all the criteria that we stipulated in the RFP. But I also have an additional recommendation, one to include the second highest ranked firm in the form of a pre-qualifying them for potential future engagements of this sort. The fee arrangement of these firms is customary, is a percentage of the salaries of whoever is being searched for. So under that, under those circumstances and realities relative to fees, my recommendation is one to pre-qualify them as well. I can take any questions or
Just,
make any kind of comments.
I guess a quick procurement process question. We're accepting or planning to vote on the acceptance of the proposal submitted by juror staff in the pre-qualification. If we select juror staff, are they necessary, or do they essentially then become pre-qualified
That's
for us
correct.
also?
Yes.
And then how does that change, or does it change the bidding process in the future if we go out looking for the search firm's help?
Well, it shortens it. It allows us to take what I'm seeing here as the best two and engage with the one that is ranked the highest for what we said we would do, which is the search of the executive director. So that complies with the procurement rationale from the get-go, but or that we set out to do originally. But in addition to that, my recommendation is to include the second highest ranked firm for a potential procurement. We may not have one, in which both the first and the second would be considered in that future. Now, this would allow us to essentially shorten a potential future procurement.
Okay.
Because we would only select from either of the two.
Okay. Thank you.
Commissioner, I have one question. If I'm understanding this right, jury staff did very well. They got 15 points because of the fee arrangement. And I look at the lowest ranking, Spencer Stewart, got 3 points. That's a difference of 12. If that 12 weren't there, if they both got 3, jury staff would be lower than Spencer Stewart. And I'm wondering whether we want to make this decision fundamentally based on who's the cheapest, or else who's not the most expensive. If we,
Yeah.
I felt very strongly when we first started this process that, yes, we want to be prudent with our money. That's an absolute, no question about it. And all other things being equal, we should, go for the least cost. But I was not anticipating that we would have cost be such a dramatic driver of the decision here. And I wonder what other people's thoughts about that are.
Mr. Chairman, had a question about the same issue because, for a variety of reasons, and because I was interested in what the delta was. Everybody has a cost, so the difference, what's the difference between the costs that will incur with the others and the costs that we would incur if we took Spencer Stewart? So it's still it's a question along the same lines.
Yep. Let me, before I talk specific costs, let me mention something which is, I believe, key to deal with the cost issue in general. the evaluation criteria that weighted experience, familiarity, the response, and cost, all of that was set in advance. In other words, we wrote it into the request for proposals before we received the proposals. So in that request, we said that cost would amount to 15%, actually 15 points out of the 106 that were ultimately going to be evaluated on. So, and we delineated that the way we would parcel that out was in the sliding scale of 1 through 5, where 5 is the most advantageous and 1 is the least advantageous. So there's a proportionality of points assigned on that scale. Now, the reason that I came up with these 15 points was that cost would not be the only driver. It is a consideration, but it's not the only consideration. And I just took that to be 15% because we needed, experience and familiarity with the industry and executive search type firms level to be, the majority of the experience that we were looking for. Now, the 3 other proposals besides Spencer Stewart were right around the same level, between $45,000, $55,000, which is why I graded them 4 and 5. 5 being the most advantageous, that results in 15 points, or 4 that are right around there that result in 12 points, because that's the proportionality. Spencer Stewart was at 120,000, which is essentially double the second highest, and that's why I rated them a 1, because it was the least advantageous proposal when it came to cost.
What is the proposal for jury staff is how much?
45.
45, okay.
45 for jury staff, 30% for of the salary, of the first year salary is the second highest new leadership group. That comes out to a range because we have been exploring a range for the salary of the executive director, but it's in the same neighborhood. It would be 60,000 if it was the highest range of the last memo we received from Spectrum and Michael and Carol. And 55 for Isaacson Miller. So now, by the way, Spencer Stewart scored the highest in 2 of the criteria. That was, however, not enough to offset also equally high marks of the other firms when it came to experience and recommendations.
Yeah. Well, that's a lot of money. So I guess I'd be interested in knowing Commissioner Cameron and also Elaine Driscoll were in the oral interviews with you, right?
Yes.
If you set money aside, just sort of talking casually for a minute, do you all feel, if you take money out and the money is even, Spencer Stewart, if I did my arithmetic right, Spencer Stewart gets a 76. If everybody got a 3 on money, then the 3 others are tied, and Spencer's at 73 and Spencer Stewart's 76. So it's not a huge difference. So I guess what I'm asking is, what was your personal reaction? If you set money aside, do you feel like we're getting very, very good services? Or are we doing the right thing here?
Mr. Chair, I can speak to that. I was part of the interview process. I did not review scoring the resumes, but I did participate in the interview process, and I was very impressed with juror staff. The individual who came to see us was extremely well-prepared, did his homework on the commission to the extent that no one else did, and very anxious, and gave us some good strategies on proceeding with our input. Their interview was the most impressive to me. Everyone interviewed well, I thought, but this particular firm impressed me the most, and we did have those discussions after. Spencer Stewart was excellent also. But what really impressed me was they really would like to have a book of business in government, and were willing to roll up their sleeves and work very, very hard over the summer months, which the other firms all cautioned us that would be a problem, it would slow down the process. And this particular company said, look, it's a little harder, but we're willing to work harder, and were persuasive in their ability to do this for us in a timely manner, but yet do it very, very well.
Okay. And Mr. Zuniga, I assume you felt the same way. So I'm happy with this outcome under those conditions.
Can I just put that in perspective, because the way we set this up is about 3 or 4 meetings ago, and we designated, the commission designated Commissioner Zuniga to be in charge of this procurement and to rely to such extent as he deemed appropriate on the advice of others at whatever stages he thought that advice might be helpful. So the result is that he did and handled the entire procurement and the entire scoring, but brought in for the interview processes to give advice, feedback, and act as a sounding board, Commissioner Cameron and Director Driscoll. So that's the context in which all of that occurred. So I'm sorry, did you want
Thank you.
to
No, that's very relevant clarification for the record. I also want to highlight other pieces that ended up factoring into the higher scoring here, which is again something I designated prior to the RFR being put out, and that was 3 additional points for participation in the Small Business Partnership Purchasing Program, and 3 additional points for being a minority certified or a women certified business enterprise. Even though they seemingly are small or a few points, they end up making a difference when firms are close in their ability to do the work and the responsiveness of their technical proposal. So that's another piece that goes for both jury staff and the new leadership group in ranking or obtaining a bit of an edge, if you will.
Right, but I noticed that even if you back those out, you still have jury staff number 1 and new leadership number 2. So I think it's the right thing to do. I think it's good. I'm glad we did it. But as a practical matter, those points don't change the scoring bottom line.
Well, they do change if you take out the cost out as well. And I don't know if that's what you meant, but
No, not with the cost also.
Right.
Right,
Yeah.
not with the cost also. I just meant as a standalone.
Right.
I'm comfortable with this recommendation.
All right, any further discussion by anybody on that before we have a motion from Commissioner Zuniga? All right, let's have a motion from Commissioner Zuniga then.
Thank you. I think, with your permission, I will make 2 motions because I have 2 recommendations, if that's okay. The one relating to the procurement and selecting jury staff as the highest ranked firm to help us conduct the executive search for the executive director, as presented in my memorandum.
I second the motion.
All right, again, we're going by roll call. Commissioner Stebbins?
Aye.
I should have asked if there was any further discussion, but, so I'll interject that question at the moment. And I hear none. So Commissioner Stebbins, your vote stands. Commissioner Cameron?
Aye.
Mr. Zuniga?
Aye.
Mr. Chairman?
Aye.
And I join. So the Motion is carried unanimously.
With your permission, will make an additional recommendation. This has to do with my recommendation to pre-qualify the second highest ranked firm, the new leadership group, in the event that the commission should need and decide additional support for an executive search firm or executive search tasks.
Is there a second to that motion?
Second?
Discussion. Let me ask a question. If for some reason juris staff, and this is I know, an extreme hypothetical, juris staff were unable to complete its task, does this motion mean that the next firm would automatically succeed to its role?
I wouldn't characterize it as automatically, but that's an option for this commission that we could entertain at that time.
Would an option for the commission also be, if we approve this motion, to reopen the search in the event juris staff were unable to complete its role?
It's also certainly another option, yes.
Okay.
Did I understand correctly earlier on when Commissioner Stebbins was asking that this would mean, Commissioner Zuniga, that we would be able to pick from two pre-qualified firms if we needed help or help other searches or other kinds of HR help?
That's correct as well.
Okay.
All right, any further discussion? Anything you want to add, Commissioner?
Well, on that note, in terms of options, and if we want to discuss that, we can do that now. We could pre-qualify not just the second highest ranking, but the third highest ranking as well as the second highest ranking. It might be pre-qualifying a lot of people, but in terms of options, that's also another option.
Is there any harm to pre-qualifying the top three?
There is none. There is additional options.
I mean, that would have to make the process somewhat easier, because then we'd have three qualified people we could go out and solicit bids from, because I'm assuming a lot of the search work we're going to do from after the executive director slot, the budgeted amount for the search won't be as high.
Yes, that's effectively yes.
Based on their formulas or kind of what their projections were for this position, everything would probably be below the $50,000 threshold.
Correct.
There may be minima in there, though.
Meaning,
In other words,
Yes.
maybe some firms may say, we're not going to do a
That's
job for
correct.
less than X.
that's correct.
Right.
Right.
That's correct.
But that's their option.
That is an option.
But would you accept an amendment to your motion then to,
Absolutely.
Commissioner, to pre-qualify both the second firm and the third firm?
That's totally fine.
And their names, just so the record will be clear?
Yes, that would be the third highest ranking firm is Isaacson Miller. As per the evaluation score sheets here.
Okay. Commissioner Cameron?
I have no comment. Do we need a second on that amended motion?
Yes.
I second the amended motion.
All right. Any further discussion now on the motion, which, as reformulated, is to pre-qualify Isaacson Miller and
New leadership group.
new leadership group for search assistance to the commission at some future date?
As well as jury staff.
Jury staff was the subject of the first motion, and they're already designated to undertake the search for,
And to do subsequent work if you wanted.
yes, that's right.
That's
Yeah,
correct.
that was the subject of the first motion.
Right,
And-
okay.
Okay. So it's reformulated now. This is to also qualify those other two firms, pre-qualify those other two firms. And that's been seconded. Any further discussion? Commissioner Stebbins, how do you vote on that?
Aye.
Commissioner Cameron?
Aye.
Mr. Chairman?
Aye.
Commissioner Zuniga?
Aye.
And I join, so that motion likewise carries unanimously. That brings us to a discussion of the subcommittee structure. And so let me take that one for a second, if I might. Last week, we talked a little bit about what the search process would look like, and I don't have a formal proposal for today.
Commissioner, could I interrupt for 1 second? I'm sorry.
Sure.
This may just be me, but the streaming video has frozen. I don't know whether that's me or the video, but if somebody there could double check to make sure that it's not everybody.
I've gotten an authoritative "it's you" from the technician.
Thank you. I'm not surprised.
Hit refresh, and you'll be streaming
All right.
again.
Thank you.
Maybe both. So I do not have a formal proposal for today, but the framework that I discussed, and we discussed a little bit last week for the search itself, would essentially look like this, or I would propose for your thinking that it looked like this, that once we engage and finish the contractual work that we need to do with the search firm itself, that we do as much of the infrastructure work with that firm at a public meeting. And by infrastructure work, I mean the creation of the job description, creation of a timeline, creation of a discussion of what the process will look like, and that we do that in a public meeting. And then that we designate a group of us, of fewer than 3, to act as a subcommittee to conduct the actual interviews. And that those interviews be conducted in accordance with the requirements of the open meeting law, which permit, if it is necessary to do so, that those interviews be conducted in executive session. And then that the subcommittee bring back, after the process is completed, to the commission for its consideration in a public session, the finalists for the position. That's what I would propose to do. And I've asked if we agree that that in general is a proposal and an approach worth considering. I've asked our counsel, Anderson and Krieger, to put together an outline of the mechanism that we would use to effect that and ensure that we could go forward in that fashion. So I think it's worthwhile just discussing that at a high level, without detail, discussing it in principle, if you will, so that we can get them to work on, get Anderson and Krieger to work on that approach, and have a proposal to put before the commission next week, so we can get this thing, this process started.
Commissioner, I'd like to speak to another way of doing this, another possibility. I have real concerns about candidates having positions now and being very, very hesitant. I mean, very strong candidates that would be, we would want to have as part of the process. And I think that they would have real reservation of doing that. Any kind of a subcommittee, even in executive session, all that would have to be public at some point, and I just think that will not serve us well as a way to move forward. I think we've had success appointing one commissioner, and I would have a lot of faith in one commissioner moving forward with the search firm. I think that'll help us on a timeliness as well as complying with all the rules. This is not something we want to do without a process. But I just think for the reasons of confidentiality and the reasons of timeliness, I would propose going forth with one commissioner working effectively with the search firm and our gaming consultants, by the way, who have volunteered to help us identify strong candidates for the position. And I would be comfortable with that method, and think it could be very effective for the commission.
I have a procedural question to what you were commenting on, Commissioner McHugh. In your scenario, the subcommittee will bring back, you said, a finalist, one, or finalists, plural?
We decide that.
We decide that?
And I would hope there would be more than one that the committee, that the subcommittee brought back. I'm sorry, Commissioner Stebbins, did you want to say something?
I appreciate the first piece of this. I mean, obviously laying out as much as we can to the public in terms of what the process is going to be. And I have a similar concern in, my experience in being on search committees for a superintendent of schools, which certainly, depending on the community, draws no less of politics into the equation than the executive director of the new gaming commission. Being able to work through that process where candidates who didn't make it to the second round had that confidentiality protected is, again, we want to make sure we get the biggest pool of the best candidates, and I wouldn't want anybody to feel, I don't want my boss to know I'm looking around, or my superintendent's case, they didn't want their own community.
Commissioner Stebbins, could you be sure to speak into the mic?
Yeah, sorry, I'll pull it a little closer. Certainly you don't want a board or a commission, or even, in the case of a superintendent, a community, knowing that you might be out looking for, next step in your career. So I'm interested in kind of protecting the confidentiality at that earliest standpoint, even though obviously anybody who becomes a finalist is going to need to understand that, their name is going to be out there in the public. So the process, not only, outlining the process not only helps the general public, it helps the candidates know what the process is going to be and that we need to adhere by it. I have a question with respect to our practice kind of going forward, that we have not announced candidates for employment until they've gone through a thorough background check. Well, we're kind of flipping, how do we maintain that? Is it going to get flipped around for this position? We'd be subjecting a candidate still kind of in a confidentiality phase to undergo a background check before we present finalists, or before we present a finalist.
Well, it seems to me that we could certainly think that through, and it seems to me that, for example, you could get to the 3 finalists, do the background check, and then present them here for the final interviews, or have the final interviews and then do the background check before making the selection. In some way, it seems to me that is doable. I share the concern about confidentiality to the extent that it impedes qualified applicants and people we'd like to get from coming before us. I also have, as we all do, a desire to ensure that this process gets us to the end safely and in conformity with the restrictions that govern the process. It's the most important decision we've made thus far, and that's why I have asked our council to take a look at all aspects of it, and particularly when does the confidentiality evaporate piece, so that people can be assured, if they otherwise would be reluctant to apply, that their application won't lead to a revelation of their names contemporaneously or at some point where it might do them harm. I think that's fair, and I think that's a standard in an environment where you're trying to attract the best people you possibly can. So I'd like the lawyers to pay particular attention to that and to come back to us with an assurance that that can be done. We're not the first group to face that issue, and I think careful preparation in the beginning will allow us to proceed through that in a way that assures us that we've thought through the ramifications of what's going on. So that's what I propose to do. Commissioner Cameron?
Yeah, I still believe that with one commissioner, we can handle that confidentially. That's a huge piece of this, and I'm just not convinced that a subcommittee can be handled in that manner, and from what I know about the law, it cannot be. So I don't think our lawyers are going to be able to give us or our candidates that assurance. And in the early process, I think that is paramount to this search. And I think people of high quality with gaming experience will have other jobs that they will not want to jeopardize. And I think that can be said for any one of us. And so I think protecting that process, but handling it, using the process in a way that makes sense is something we should consider. And again, I get back to the timeliness of this issue. I think it's critical that we move this process along. It'll help us with everything else we do as a commission. And again, I get back to I would be very comfortable with one commissioner moving forward in the early stages. And I don't think we can dictate the end stages. I think there may be one or two candidates that really rise above the others. We just don't know. And at that point, we would proceed confidentially with background investigations.
Mr. Chairman, is there anything you wish to say at this stage? Thanks. I think we all agree in principle. It seems like everybody agrees that confidentiality needs to be assured in all of the preliminary phases. The question is our belief in the system, the confidence in the system, and Commissioner Cameron is expressing some concern about that. And as a practical matter, even if there is legal protection and we feel comfortable that the names could stay confidential, I'd still have to think through how would a subcommittee meeting take place? Would we be trying to sneak people in the back door after so it's not merely a legal issue. I think there's also some practical considerations. But my suggestion would be that we move forward ASAP with jury staff, get them started on the job description and whatever else it is they need to get started on. Tell them that we want them to come in, and we all agree, I think, with Commissioner McHugh that all of the infrastructure stuff, the preparation stuff, can be as public as possible. Put them on the agenda for next Tuesday, and meanwhile, finish up Anderson and Krieger really looking into this hard, and have Anderson and Krieger come to the meeting next Tuesday also, where they will explain the legal situation, we talk through the practical situation, and we then decide. I don't think postponing a decision on whether or not to have a subcommittee today as opposed to next week slows anything down. We can get started ASAP anyway.
No, I only brought the subcommittee idea up today so we could think about it at a high level. I was not intending to have a vote today, and I really do think we need to have the thorough analysis by the lawyers to make sure what it is. So that sounds good. Commissioner?
Yes, I could, in the analysis that the lawyers could help us do relative to the subcommittee, could they also look into this option of appointing one commissioner for this search and any ramifications that would have? In other words, have perhaps those two options weighed against each other, from their experience and understanding.
Surely, we can surely ask them to do that, and will.
So you have both the search for Amanda lawyers coming next week.
Yes. Yeah, we certainly can have the search firm if they're available, and I will ask the lawyers to come in next week with a response.
Okay.
But I want to assure them and us that they have enough time to give us a high-level and thoughtfully considered opinion. That's the only gating factor there. But actually, we don't have to make that decision next week either, because we'd like to, but we don't have to make that decision. So I'll see if they can do it by next week and try to get them to do it next week, and if they can't, we'll do it the week after.
And just to be clear, that whichever path we go down with, either a subcommittee or one commissioner being responsible, that we'll have the services and support of our gaming consultants to assist in the search and recruitment effort, as well as work with jury staff in terms of making recommendations about advertising, completing the executive director job description, et cetera.
For whatever is worth, more than two firms pointed out that the summer was going to be a bit of a challenge in terms of reaching out to potential candidates. So we have a little bit of time, if you will, only because it's not months that are as active as the rest of the ones, but it's a total side note.
All right, so let's, next week, seek to have the Anderson and Krieger representatives, if they're finished their work, and the Juris staff people here to begin the process of moving us forward with this critically important search for an executive director. That brings us to item 3B on the agenda, additional hires. Do we have any further information there?
We have Heather
I think
Fong.
we are, I think we are, we'll be able to announce a Director of Administrative Services within a day or two, but we can't do it right at this moment. And I think that Janice has one new hire to announce.
All right, and that's your cue.
For Heather Fong, starting July 9th as our new receptionist. And we have an EA candidate going through background check right now, who hopefully will be coming on board in another couple of weeks.
And Ms. Fong has successfully navigated the background investigation and all other prerequisites. All
Yes,
right.
she did.
Great, that's terrific. Okay,
Just one other thing on that, Commissioner. We, I think, just as sort of a reminder, we had the conversation last week, which I think was a very good one, about soon beginning the start a search process, whether we use a search firm or not, we haven't decided, but start the search process for other critical hires so that we have the candidates teed up when the executive director comes on board, or we may have to even make some decisions before that. And I think that's something we might talk a little bit about with jury staff, what kind of lead time do we need and so forth. But I think that was a very good point. I want to make sure we don't lose that.
all right, Mr. Chairman, thank you. We'll make a note of that and put that on the next agenda. Okay. Gaming Commission internal policies. Commissioner Zuniga.
Thank you. We have drafted and quality reviewed 4 chapters of the employee manual. I have 2 more about to be reviewed and forwarded to Commissioner McHugh for that quality review. And that would complete what we're envisioning the employee manual to contain at this point. So I believe that in the course of next week, or this coming week, even though it's a short week, we could come out of next week with a final draft for consideration by the full commission on the employee manual. None of these would include the enhanced code of ethics that our outside counsel is currently working on. This has to do with just about everything else relative to employee manual and procedures.
All right. You've put an enormous amount of work into that, and it's good that it's nearing completion. Is there any other discussion about that? We'll take a look at that. So we certainly, with that one, would need some advance time before we were ready to vote on that. So the idea maybe would be we'd have it on the table to ask a few questions about next week, and then maybe vote on it the week after, something like that.
That could be, yep, that could be doable.
Okay. All right.
Makes for a lot of great reading over the holiday weekend or
Yes.
something like that.
It's lively.
It's lively.
Yeah. All right. Any further discussion? Hearing none, the project management consultant, again, Commissioner Zuniga.
Yes, thank you. Following up on prior conversations and directive for me to look into project management firms, specifically with somebody who could help us with the scheduling and management of different scenarios as we put out our own RFA Phase 1 and Phase 2 processes. I conducted a small procurement which consists of requesting 3 quotes from qualified firms And I have put that description and those responses summarized here in the memo that you should all have in your packets. These are all firms that normally do a lot of construction and project management. I try to summarize that they represent a bit of a wide range in their size, but they're all local, and have supplied very comparable quotes, if you will, where one is clearly the most advantageous. PMA consultants here has a approach and a combination of project executives and staff people that results in the best and most advantageous quote for what we envision this to be an 18-month effort on a part-time basis.
All right?
I can take any questions to the memo.
Who all saw the tool that PMA would use? Excuse me, am I interrupting somebody?
No, that's, you were speaking into quiet.
Okay. The tool that PMA would use, who has seen that?
I saw it. I saw I met with the PMA folks for a demonstration, and it is a highly interactive project management tool. It has a lot of the features of the standard Microsoft project management tool. But those features are all in the background. And what this tool does most helpfully is allow you in real time to take chunks of work and milestones and every other facet of the project, move those around chronologically, and then have everything else fall into place behind the movement, so that you can tell instantly the effect that extending a deadline for 3 weeks, or missing a deadline by 2 weeks, or advancing a deadline by a month will have on every other facet of the project. And it does it graphically, and it does it in a way that allows people to get together and actually talk about the consequences of doing one thing or another, and having those consequences appear in real time, and then capturing the results in the form of a PDF that everybody can take away and work from. And as we get deeper and deeper into this, it seems to me that the scheduling of the various events that are going to occur with respect to hearings and desired end dates for license awarding and the like are going to take on a level of complexity that really would benefit from this kind of tool to allow us all collectively to brainstorm in these meetings, if necessary, and see what the consequences are. So I think that tool is a terrific device for us.
Yeah, I want to emphasize something that you said very, in there, which is what PMA has done. The database behind all three options, everybody uses the same database, if you will. But what PMA has done is overlaid this graphic tool that Commissioner McHugh was just describing. In the background, the same database, either something in Primavera, P3, or Project is really at work. But this overlay that interacts with that is what's really intriguing and powerful, especially as it relates to the work of the Commission. Because I think we will need to evaluate different scenarios as we are implementing them. And that's very important to have us all understand.
Is this a proprietary tool, Commissioner?
Yes, and the cost that they're proposing here includes a licensing for multi-users. In other words, there would be up to 5 people at the Commission that could log in at any given time, but it could be many more if they're not at the same time. But we obtain all the database in any form we wanted, meaning we could have, all the dependencies, activities, et cetera, in project, in Excel, actually both. The data is all ours. It's the overlay that reports in the graphic form that we would get licensed, that we would pay a license fee, I'm sorry.
And we could continue to use that even if they were no longer working for us.
That's correct. That's correct.
I was not available to see the demonstration, so if I'm asking questions that I hope you have the answer to. User friendliness, I know that's a huge piece in a successful software project of any kind. Is that a user-friendly?
Yes.
Instrument?
Yes, I would characterize it as very user-friendly. These, the genesis of this tool tells a lot of the story, which is the clients like us at the executive level, where being bogged down in too many little activities, and there was this real need to have something that was user-friendly. And I think to a great degree, they have accomplished that by summarizing and being able to do this very interactive tool. Now, just a little caveat, the more, it's still a tool. We could end up, and I hope we don't, putting in too much detail where eventually it becomes less and less manageable. But I'm very, having used Primavera and Project in the past, I was very encouraged that there's this next generation that I wasn't familiar with, which is this graphic planning method that I believe really can help us.
This isn't like Angry Birds, though, we'd all have to have a little training to do it.
Yes.
But I think
That's right.
Some of us,
I'm
some of
sorry.
us might need a lot of training.
Pardon me?
Some of us might need a lot of training.
Well, that's certainly a possibility, but
kidding.
I mean, you can move the stuff around, it'll work, and we can work it.
Well, what I think is relevant here is that this is a step further into having people, again, like us, understand the real inner workings of a schedule, whereas tools like Primavera, there is this, because this is so complex, they would end up creating this black box sort of mentality of, we need to have somebody who really knows how to manage that and just tell me what the results are. I think this tool gets us much further away from that to where we need it, which is one of really understanding what's behind dependencies and dates and milestones.
Okay, any further discussion on the proposal?
Commissioner, what would be your sort of plan of action if we approve this? What are the next steps? How do we get moving?
All three firms, by the way, had a similar approach, and that is that they would envision, we would all, and this is what we're envisioning, a 2-week or so period of initial consultation about key milestones, some of the current thinking. That could be done on a facilitated session as one of our own meetings, but it could also be done by this firm having discussions with our own consultants and our own lawyers who have an understanding of some of the dependencies that we're already working on. So this 2 or 3 week sort of phase, setup phase, I would characterize it, would be the next step.
And during that phase, we could see whether we can automatically import the consultant's work plan into this work plan, which if it's based on Microsoft project, we probably can, and then move forward with an integrated plan.
That's right.
Right.
We could start discussing what components we want. We don't start from scratch. There's a real work already done in Excel, but then we need to start laying out the rest of whatever's not in there.
Yeah.
I think it'd be a great idea to have them come to the meeting next week and show us, but also everybody else, what we're going to be using.
Sure can, and the tool can be projected, and we have the capabilities here, so they could actually present it on an overhead projector.
All right. Any further discussion? Would you care to make a motion, Commissioner?
So I'd like to make a motion to accept the proposal submitted by PMA Consultants as outlined here in the memo that I have submitted as part of the packet, and begin negotiations with them relative to timeline and contracting for scheduling management services.
Second.
Further discussion? All right. Commissioner Stebbins, how do you vote on that motion?
Aye.
Commissioner Cameron?
Aye.
Commissioner Crosby? Mr. Chairman. Commissioner Zuniga?
Aye?
And I join with an affirmative vote. Mr. Chairman, I should have asked you this earlier, but this is a good opportunity. You've been provided with all of the documents that we've referred to thus far in the meeting, in advance of the meeting. Is that right?
Yes.
Okay. Racing Division is the fourth item on the agenda, and we're at that fourth item now. So Commissioner Cameron?
Thank you, Commissioner McHugh. At this time, I would like to file a decision document with the full commission. This is in the matter of Ms. Judy Ray. We are in the process of finalizing our procedures here. This was the first hearing that the Gaming Commission had, the Racing Division, so we are finalizing our process. And at this time, we'd like to reach out and have Ms. Ray sign off on a document that would simply state that she has no intention of appealing this decision. And at that time, we will have that document, and for next week, we could move forward with ratifying this decision. There were three other matters that came before me as the presiding officer of the Gaming Commission with our first adjudicatory proceeding on June 21st. The other three matters, as I just alluded to, we have some procedural process issues that we are just working out, and I will be prepared at next week's meeting to file those documents. The other thing I'd like to report on is the fact that I was out last Thursday and Friday of last week visiting casinos / racetracks, one north of Philadelphia, one south of Philadelphia, Parks and Harrah's. I was most interested in looking at the racing regulations, the state-of-the-art facilities being one of them being a brand-new facility, the other being one that was completely refurbished. And it was a learning experience to look at the state-of-the-art licensing procedure as well as testing procedures that both of the tracks are now utilizing due to their the ability to implement those. So we are, as you know, looking at all of our procedures, all of our regulations with regard to racing. And I also met with our racing expert, Ann Allman, during this visit, and she is close to completing her project for our commission, and we'll be hearing in the near future from her as far as her recommendations for us moving forward with racing. And that concludes my report.
I should mention, Commissioner, that with your permission, I signed last week the 2 ISAs that were necessary with the Department of Public Licensure that were necessary to get us through to the end of the fiscal year just concluded, and I understand that the ISA to take us forward is in its final stages. of
Yes, I
preparation.
just signed off on those documents before the meeting today.
Great, so we're all set for going forward as well. Any questions or comments or thoughts about the Racing Division report? No action items there now. Okay. The project work plan. Could we talk with you, Kathleen O'Toole? Good afternoon.
Good afternoon, Commissioners.
Nice to see you.
Good afternoon.
You can start anywhere you'd like, and there's some questions that I think we'll have, but
Kathy, would you put the microphone
Certainly.
next to the,
Yes, good afternoon. For the record, I'm Kathleen O'Toole, and I'm here again to provide an update on the consultants' work. I'll provide a highlight of the work that occurred during the past week. The two consulting firms, both Michael and Carroll and Spectrum, participated in several meetings last week with representatives of the Commission and other state agencies. For example, the consultants and Commissioner Cameron met with representatives of the Attorney General's Office, the State Police, and the Alcoholic Beverage Control Commission to discuss protocols for investigations and enforcement going forward. I understand those conversations were very productive. There were also meetings with Commission representatives and various personnel from administration and finance to discuss the Commission's organizational structure. So all of these discussions continue to help inform the consultants in their development of the Commission's strategic plan. Most noteworthy during this past week is the progress on regulations. A draft of approximately 100 pages of regulations was forwarded by Michael and Carroll to both Spectrum and to the law firm Anderson and Krieger on Friday afternoon. The consultants and the law firm will iterate this week, make some revisions, and then forward those draft regulations to the Commission early next week. The draft regs fall into two different categories. The first category relates to Commission administration, and the second category will be the regulations required for the RFA Phase 1 process. So according to the time frame we've all discussed in the past, there will then be a 3-week period during which the Commission and the consultants will work to finalize these regulations. If all goes according to plan, the Commission will be able to do that at its meeting on July 31st. So I would say we could use some guidance, I'd say, in terms of the submission of the draft regulations early next week. I'm not sure if the Commission wants us to, if the Commission will designate one person to accept those draft regulations for review, or whether there'll be a number of commissioners involved in that process.
In the review process, well, it probably makes sense to have the draft regulations forwarded to the chairman. Mr. Chairman, what do you think about that?
To then be distributed.
To then be distributed, yes.
Right.
And so that would be the point of entry, I think.
Well, it's important to note, I would say that, so the draft regulations are in fact draft, in
Right.
draft form, and over the course of the 3 weeks, it will require a significant discussion between representatives of the Commission and the consultants.
Kathy, could you speak a little straighter into the mic? I can't quite hear you, I'm
Certainly.
sorry.
No, I was saying, Chairman, that, so the regulations will be in draft form, and over the course of the following 3 weeks, it will require a significant amount of interaction between representatives of the Commission and the consultants. For instance, in some cases, the consultants will offer different options, and the Commission will need to make policy decisions as to which options are most appropriate. So again, these will be in rough draft form when you receive them next week, and will require additional work during that 3-week period leading up to July 31st.
Right.
So Mr. Chairman?
I got it.
So we,
That sounds fine. The only thing I would, actually rethinking this, Commissioner McHugh, as a practical matter, we have delegated, or I guess technically I'm the project manager, but as a practical matter, we delegated that role as kind of the key point of contact to you, particularly on something like this, the issuance of regs. So consistent with that, maybe it makes more sense to have the draft sent to you. We've also agreed that you will then forward them, but I actually think it makes more sense to have you be the initial point of contact.
all right, and then I'll forward them to the other commissioners, and then we'll figure out how to parcel out the kind of interactive work that needs to be done and what pieces of that interactive work really rise to the level of policy so that we can bring them to commission meetings, talk about them, and have the process move forward. Remembering, and everybody watching on the streaming video and for those in the audience, that this is all preliminary to filing a set of proposed regulations with the appropriate authorities and ultimately having a period of public comment and a public hearing on the content of the regulations so that we get the public input and the input of all the interested parties before the regulations become final. So this is way, chronologically, not necessarily way ahead, but this is in an early incipient stage of drafting so that we can have something that the commission is prepared to put out for public comment. And it may be that some things ultimately are put out for public comment that the commission is not necessarily wedded to, but things should be put out for discussion and commentary before making a final decision, so that there's a lot to be done between now and the time these regulations become final, and we'll do all of those things. Okay, so I'll get the regulations, I'll distribute them, and then we'll figure out how to go from there. I'm sorry.
You know, I was actually going to make a comment relative to these reports that I think fit what we're thinking about relative to the regulations. It would be very helpful to me, but I'm sure to the rest of the commission as well, if the consultants could summarize for us, we don't need necessarily a written report, but the key strategic considerations week to week, if you will, that this commission needs to at least understand. That's part of assumptions behind a memo, or that are really, that may rise to the level of policy decision sometimes. So if we could, regardless of format, if you could highlight for us, again, on an executive type summary, what to look for when we're reading the amount of memos and paper that's going to come our way, I think it would be most helpful in terms of process and understanding. So
We'll definitely do that, Commissioner. We've also kept we keep a log of all the memos that have been submitted to the commission to date, and I had a discussion with Commissioner McHugh about this. Perhaps it would be helpful if we provide a brief synopsis of each one of those, so all the commissioners will have them readily available.
yeah, and I'm less interested in those that were for our information, although, you know, a synopsis of that is just fine. I'm more interested in those memos that contain what could be a policy question, or that you're not waiting for us to weigh in because that has a subsequent implication of another memo. That's what I'm more interested in. So rather than try to blanket, send you on an executive summarizing mission, I'm more interested in what could we, certainly going forward, or whatever is needed up until this point, need to weigh in or accept that has been vetted or agreed upon by virtue of that summary level.
Commissioner, would it be accurate to sort of say, to ask the consultant to basically just give us a heads up on those issues, those sections of the regs which are really substantive and likely to be policy matters, as opposed to the whole bunch of boilerplate that if we're short for time, we could just as well skip. Is that basically your point?
Yeah, I would agree. I think, again, if they had, put another way, if they're gonna drop a 100-page regulation, if they could highlight for us in yellow what's really important, that would be another format. But,
Whatever is easy, whatever is easy for you to do, for the consultant to do, they've got a lot of work. But I think it's a very good point. It would be helpful to us in whatever way is easy for you to do, Kathy.
I think that'll be efficient for it'll be helpful to everyone.
And coming back to the summary memo, well, that's not as critical in a going forward basis. An updated sort of summary memo that we just add to as these new memoranda come in, I think would be a helpful thing for me, and it might be useful for others as well, just one or two lines about that so that we can remember as you look at that and as we read the regulations, as we get deeper into this, what we already have in more detail in our library, so.
actually,
that
yes,
would be
it could help tremendously, indexing and then going back and looking in
Right.
case we need to.
Right,
Yep.
so that's just two little pieces to pull things together.
That's great.
Anybody, any other comments or thoughts? Anything else, Kathy?
No, Commissioner, that's it. Those are the highlights for this week.
Okay, they are great.
I'm sorry, excuse me, Commissioner.
I'm sorry, Mr. Chairman.
We talked about this the other day. We need to think about whether we are going to need to alter the scope of the existing contract. Are we going to need to go out for some kind of a procurement for other people to help us in the background checking process? I don't know if we're ready to have that discussion, but I think we agreed that we can't wait very long to figure out where will we be in the process once the existing contract is concluded and the existing committed funds are used. And if we're still in the middle of the process, we have a lot of work yet to be done, somebody's going to have to help us, whether it's this consultant or somebody else. So I just wonder if there has been any discussion or thought, Commissioner McHugh or Kathy or Commissioner Zuniga, or how do we pick that up and get it on the table? Because if we do need another procurement or an expanded scope, we need to start thinking about it pretty quickly.
I have not given that any thought. I've been focused, as I think we all have, on trying to get this piece of the work done. But I think you're absolutely right. And I think we ought to take a look at the existing arrangements and refresh our recollection as to the contours they contain, and then figure out, and if necessary, start an early discussion about where we go next.
Right. Commissioner Zuniga pointed out that
Speak to that.
technically the contract, I think, is it runs a 16-week process, and but the work product on the flow chart is still coming out come middle of October. And that may well be understood by somebody, but I don't think it's clear to all of us. And that, too, needs to get addressed.
Yeah, let me speak a little bit about, just contractually to try to, perhaps at the risk of oversimplifying, we engaged our consultants to do a strategic plan, which is what they're working on, and many of the components they are, in fact, doing. But to the extent that we are, by virtue of accelerating the schedule, implementing or having them do work that has to do with implementation of the plan, rather than just formulating the plan. That's what prior to that, we really need to start thinking about the next procurement piece, or how to compensate them for that part of the work that wasn't contracted on. So in that venue, we'd like to hear from our consultants later, now or later, when we are approaching, if we're approaching those eventualities of implementation, so that we can account for that.
So maybe maybe the,
I think there's nothing, is there anything more we can do on that topic today, or do we need to simply raise, as we have, the issue, and then go back and regroup and think this through a little bit before we go further? I'm not suggesting we delay this, but
no, I think that's right, but maybe formally put it on the agenda with the consultant next week, if by that time we can have all thought it through.
all right. Does that make sense, or should we talk further before deciding when to put it on the agenda?
I'll defer entirely to the commission on that. The consultants have made it clear that they're just focusing on the 16-week
Right,
period and trying to
right.
get these regulations produced, and also, but I'm sure that they would be very interested in discussing the plan going forward.
Okay, the only reason I raised that question is we really are in a crunch period here with these regulations. They're going to Anderson and Krieger. There's more stuff going from the consultants to Anderson Krieger. Anderson Krieger's going to be giving stuff back to them this week. And we're on a tight deadline, and we need to discuss this, but I wonder if it isn't worthwhile to make the regulation, getting the regulations out, be the absolute top priority. And then we catch up with this very quickly, but not necessarily next week if it would interfere with what else they're doing. Do you have any thoughts on, I mean, what do you think of that, Mr. Chairman?
Well, I completely agree. If it's going to get in the way of the things that are on the table, then it's a second priority. But I don't think there's really all that much work to be done. I at least would just like to sit down with the consultants and sort of think this through. I don't just, sort of just talk, get a calendar in front of us and just kind of think this through. Because so if I'm wrong about that, if it requires some work, then we can certainly hold it. But I think we need to think pretty quickly about whether we need to do a procurement, because if we do, we got to get going in order to have the procurement completed in time to pick up the ball at whatever point it is.
Okay. So,
The consultants will certainly be available to discuss that. In fact, they'll be available to present the regulations as well.
next week?
Yes,
Okay,
sir.
surely. Great, great. All right, anything further then?
That's it, Commissioner.
Good, thank you very much.
Thank you.
All right, the next item on the agenda, then, the consultant's status report. I think we've just had the sub-topics there, I think are still items that are awaiting action. The effort to get the regulations out really has taken precedence over everything else. So that brings us to item 5C, technical and other assistance to communities. And the first subtopic under there is the ombudsman job description and process. Mr. Chairman, do you want to take the lead on that?
Yes, thank you. Your packages have the draft job description for the ombudsman role. There's two-part ombudsman role, which is to be an ombudsman with prospective bidders and an ombudsman with communities. And I was asked to draft something so we know what we're talking about as we begin to look for this person. And I'm open to any comments. It's just a draft, so any comments on that. And then secondly, we had talked about there, Commissioner McHugh particularly made the point that we ought to have some kind of a process for making this happen. And we were going to talk about that as well. There's nothing written about that. The concerns that I have, and we always have this, is we really do need this person quickly, and whoever it is going to have to go through a background check and so forth and so on. So it would be nice if we could move fairly quickly on this. I don't think we know whether or not we're really hiring a permanent person. It's probably a full-time job for a while or close to it, but it may have a relatively short life, and I was thinking that if it was acceptable, maybe we could hope to get it by either get a consultant that we could procure pretty quickly, or a loaned person that we would pay for from the state. But that's what the concern everybody has is we need to move quickly, but we we also need to be careful. So the process one is on the table to be discussed. First of all, let's just look at the job description and see if anybody has material changes to that.
I have a comment. It's not a material change. It's more like a topic for discussion or clarification, but it's on the job description. And in the job description, one of the activities or one of the key constituencies that this person would deal with is at the local level. And it says that that he or she would respond to all inquiries from communities, either host or surrounding communities. And I think we should, or my question is, if that's essentially the person who deals with all inquiries at the local level, and they could come from Board of Selectmen, City Council, but also associations, and importantly, from citizens in general. And that could end up being a lot of people. And if we could articulate or think through just what we are thinking about, again, at the local level, or if it's really for that person to try to organize a process, at least I just wanted to kind of throw that out there.
My thought was twofold. One was I was thinking only of official inquiries. This is for the municipalities who will have to deal or may have to deal with developers. If it's just a citizen or it's a citizens group or a chamber of commerce or something else, that may or may not go through this person, but I was not envisioning that. Secondly, I certainly was meaning that the person is just a facilitator that doesn't have to answer every question or do everything. It's just be an unknown, obvious, readily accessible, customer-friendly contact who will guide any official inquiry to the appropriate source for an answer.
So once this person was on board, if we accepted this job description, then he or she could, in conjunction perhaps with Director Driscoll, and work out a protocol that would be published and let people know what he or she could and would do.
Exactly.
Mr. Chair, I just wanted to make a comment that, you were explaining this, I believe it was last week, and I did not have a full understanding of where you were going with this, but this is an excellent description, and I agree with you that this is something we really need, and, we should facilitate as quickly as possible.
Great. What about anything else on the definition itself?
Yeah,
We can certainly put a word or two in there, Commissioner Zuniga, that make clear that this is a commitment to handle all official inquiries. And then, as Commissioner McHugh says, we can work it out later on about, where the Chambers of Commerce goes and where the anti-groups go and so forth.
Mr. Chairman, looking at the definition, and Commissioner Zuniga and I had a meeting last week with the folks at Mass Development who have just gone through the process of hiring a senior regional real estate development project manager, which I think incorporates a lot of the skills and background and experience with respect to the ombudsman position. And their commentary to us is that because a lot of these private firms have been scaling back on senior people, that when they posted their position, there was an abundance of resumes that came through the door. So I think that's, food for thought for us to have in terms of whether, we end up posting this position or how we go about recruiting anybody who might be interested in this position. And obviously, and I had a follow-up meeting this morning with the folks at the Collins Institute about their scope of services, their interest in entertaining on our behalf to help reach out to local communities. But I had a question with respect to, if you look for the protocol for prospective gaming developers' interaction with the state, we make the ombudsman position kind of go away in the postal license award process. And I would think that would, I've had some rethinking about this. I would almost see that as where that person would still be extremely valuable. The legislation puts an onus back on the community to designate one person to do the permitting at the local level to make sure the process goes through. And when the state's getting to that same point, we're suggesting that the point person who may help them is going away. So I certainly see the ombudsman role as kind of having a definitive time period, but we're asking the communities to designate a point person for the permitting process. I believe the legislation outlines some penalties.
Please pardon the interruption. Your conference contains less than 3 participants at this time. If you would like to continue, press star 1 now, or the conference will be terminated.
Are you still there?
I'm still here and I pressed star 1, so.
Yeah, we both did, so.
Right.
There's now 4 of us on the
No,
call.
So were you finished, Commissioner Stebbins?
Well, I mean, again, just kind of getting to the point of, I think the ombudsman's role may take on even a more important relevance when we get to the license the application approval process. We don't want to leave a gaming, I don't want to say we're leaving a gaming developer out there kind of on their own, but I think having a point person to continue to coordinate the interaction with the other state agencies, we're trying to position Massachusetts as a friendly
Right.
place to do business.
This one, Commissioner, the idea that after a licensee is chosen, that there'll be a maximum of 4 of them, and maybe fewer sequenced over time. And the state agencies said to us they didn't feel that there was a need to have an interface at that point. I'm sure when the time comes we could rethink it, but that was the way they wanted to handle it.
But we've not given up on that, and
No, not at all.
and have not eliminated the idea of thinking on the front end how to encourage some kind of a consolidated 40B or D, I've forgotten which it is, approach to permitting at the local level and other kinds of things that will facilitate this going forward. So that's a piece that still is in play, I think, right?
Yes, definitely. That was part of the original agenda that Commissioner McHugh and I undertook with all the secretaries in the governor's office, and we've left it explicitly on the table that we do want to talk about the post-license award process. But it's just up in the air still. It hasn't been resolved.
I just want to underscore a point that Commissioner Stebbins made prior to the first point that he made, which is some of the feedback from that meeting with Mass Development led me thinking that there could be good candidates out there, with senior real estate development expertise, familiarity with permitting and 40D and those processes, and who may be willing to come in on a contract basis.
Right.
Frankly, so it's one of the options that we should be evaluating.
Is there any possibility, as we foresee this role, that you have somebody essentially in doing the kind of the legal interaction on questions about the bill that would have the direct interaction with Anderson and Krieger, and this ombudsman role playing more of a role with respect to the permitting process and et cetera? And if we're looking for somebody with real estate development experience, could we foresee that person somehow having a role in helping us through the whole issues of identifying impacted surrounding communities just based on their experience and their knowledge of development projects? Probably not to throw out more questions.
No, I mean, I think that's
Comments, but-
certainly, now's the time to be thinking about things like that. I don't envision us setting up an environment in which people outside the commission can go directly to the law firm that we've hired to get answers. The law firm we've hired has one client, that's us.
Right.
And so I think we can't set that piece up.
No. Having somebody in office hire, in commission hire in our,
Payroll.
they could potentially become the legal department, so to speak, to help handle a lot of the questions we get about the legalese of the bill. That would work on our behalf, obviously, if they're on our staff with Anderson and Krieger, and then set aside this ombudsman role to be more of analyzing and assessing the permitting process for these facilities. And maybe those two people work side by side.
Well, I think, it seems to me that the ombudsman, as conceived, would have to have a pretty good working knowledge of what the legislation provided, and we'd have to facilitate his or her acquisition of that knowledge and
Right.
provide support, whether it was through Anderson and Krieger or through us internally or through whatever mechanism. But, Mr. Chairman, my conception of this was that this would be a facilitator for cutting through red tape, basically, to make it, to refine it as much as I can, and that this person would be a person not only with knowledge of development experience and the like, but also with knowledge of who in state government was responsible for what, so that both developers and cities and towns could be most efficiently directed to the person who had the answers.
As opposed to having the answers.
Yes, primarily, right.
That's exactly the way I envision it too. I mean, over time, obviously, the person would gain more and more expertise and would be able to answer questions kind of as a matter of course. But I do, yes, see it very much the way you suggested it. I think they would, over time, they kind of morph towards what Commissioner Stebbins has said. But that would just be sort of in the natural course of events.
So is that a different vision, Commissioner Stebbins, than the vision you have for this role?
You know, as the chairman just put in terms of this morphing into a role where I think a lot of us expect a lot of our hires are going to morph into different roles and responsibilities.
Well, morphing.
Evolve.
Morphing, evolving. And again, I just had that, you know, the one concern about the last piece in the protocol of, you know, I would argue that there's still some responsibility on our part to kind of marshal the forces to make sure that once an application is given, that we continue to work with our sister agencies and have that one ombudsman kind of stay with it and really until the shovel's in the ground.
But in
I
terms of,
don't really disagree with that. I mean, as I said, we have to make sure that our colleagues in the state agree with it, but I don't think anybody else would, I don't think they would have a problem with that at all.
yeah. But in terms of and Chairman Crosby just put it succinctly, in terms of this person having the answers as opposed to knowing where to direct people for the answers.
Right.
Are you?
No, I'm comfortable with that, and, you know, and obviously comfortable in making sure that, you know, whoever he or she is that fills this role would also partner with, you know, the Collins Institute if we end up doing a project with them to, again.
And maybe the RPAs and MMA and others.
Yeah,
Right.
exactly.
Right, right.
So, I mean, I'm happy to kind of, I don't want to slow up the process, but, you know, maybe add some of that additional job description in there if that's suitable with everybody or the chairman. I know you have a protocol piece you may want to
We're going to talk about the
but-
protocol piece in just a second, but
Okay.
in terms of the job description, do you want to put your thoughts in there and edits to that and send it back to the chairman? And
Yep, absolutely. I'll do
Okay,
that
great.
relatively quickly.
Okay. Commissioner, did you have anything further, or Commissioner Cameron?
No.
Okay. So with we're satisfied with the job description, subject to your review, Mr. Chairman, of Commissioner Stebbins' additions, comments, elisions, and the like. Okay. Then, in terms of process, we will get moving on trying to identify, solicit, interview potential candidates as quickly as possible in whatever means are appropriate. Is there anything more we need to say about that at the moment?
Well, if we're going to post a permanent job, then there is some structure we have to go through. I sort of forget what it is, but Commissioner Zuniga could tell us. If we have a sort of a presumption for starters that this would be a consultant role and not a permanent position, I think we can move more quickly, either a consultant role or a lone person from the state, which is what I was suggesting, if that's okay with everybody. If it turns out that we have to turn it into the position because we find the right person and they won't do it without a permanent job, then we can cross that bridge when we get to it. But I agree with the mass development, or whoever said it, that there are lots of people out there who have these kinds of skills who would probably be delighted to have a consultancy if not a full-time job.
Well, I think from, just pragmatically, we should post, we're discussing it now, but we should post in our website, and we should post in other places, like HRD, the job description once it's been refined, and just articulate that this could end up being a contract position, not a permanent one.
Okay?
But it could be a permanent,
Right.
I guess, however we decide to articulate that, and see what response we get from interested parties.
That'd be great.
And, that way it's out in the open.
Well, I'll turn around Commissioner Stebbins' edits as soon as I get them and forward it to you, Commissioner Zuniga, and you and Janice can have it posted however. And everybody who's got ideas, let's start moving.
And we could post this for a time that was, maybe this is obvious, long enough to get responses, but short enough to be effective. We need this person
absolutely.
soon, right?
Yes.
Like, post it for 2 weeks maybe.
Right, okay.
Right.
All right. Shall we move on to the municipal process document, which is in the packets, and to which I made some revisions following last week's meeting. The municipal process document specifically is the one headed Advisory to Massachusetts Communities that may qualify as host or surrounding communities. And we discussed this last week, and I made some revisions, some proposed revisions, which are incorporated in this document. The first of those is at page 1 at the penultimate bullet point, which begins July 2013 to May 2014. That's designed to make clear that the host community agreements must be signed no later than the end of that period, rather than that people had to wait and do them during that period. And the same theme is reiterated at the bottom of the chart on page 2. The negotiations between developers and host communities can start at any time that those pairs wish to meet, and so too can the negotiations between surrounding communities and a developer. But the regulations for the RFA2 are not promulgated yet, and they won't be promulgated before the end of the year, so that those negotiations, the Commission's power with respect to promulgation of regulations is broad under this statute. And so negotiations that are finalized before those regulations are completed run the risk of missing something that ultimately is in a regulation. But nothing in the statute prohibits or even discourages early discussions, so long as they're done with eyes open.
Could I interrupt on that point before you go on to the other change?
Sure.
I think what you did here is great and made this a much stronger document. The one thing I thought was a little bit confusing is at the bottom of that paragraph on the second page.
Right.
It says the commission will not act on a site-specific application, as if they might have such a thing, but won't act on it. And I think what it really means is the commission will not begin the RFA 2 process with an applicant until the commission has completed the examination of RFA 1.
I agree that it should be clearer, and I agree that that's the thrust of it, and I'll fix that. It's also a little redundant. The last sentence is redundant of a sentence that appears earlier on, so I'll clean up that language. But that's clearly the message that
Right.
should be conveyed, that we're not, until we get through the Phase 1 qualification process,
There is no phase 2.
there is no Phase 2.
Right.
And then the other change that I made and would propose to all of you colleagues is in the second paragraph on page 3, the last sentence, it seemed to me on rereading, was ambiguous. The last sentence of that paragraph, the second paragraph, was ambiguous as to who had to provide or facilitate provision of assistance. And I simply changed that to make sure it was understood that the commission's responsibility was to provide and facilitate even-handed assistance so that all people similarly situated got the same kind of opportunity to have assistance. So that was what that was designed to do.
I had one thought on the up above, just above the Roman numeral 2,
Right.
that paragraph on the third page. It says the commission has not yet promulgated regs regarding RFA 2, and is not likely to do so before the end of the calendar year 2012.
Right.
If I'm not mistaken, it would be that would be at the earliest. That would be amazing if we had them all done by 2012, by December 2012. So I'm just for setting expectations, unless I'm wrong, but if to set expectations right, we might say at the end of calendar 2012 at the earliest.
Sure.
Okay. I think this is a really helpful document, everybody. Thank you.
Yeah, I have a sort of comment/question around that, which is on the one end, we don't anticipate to be promulgating regulations for Phase 2 until 2013, early 2013. Or rather, we won't promulgate them perhaps prior to the end of 2012. But also the earliest subsequent date is April of 2013, when we are tentatively, this would be the earliest release of RFA Phase 2, correct?
It's the earliest likely date.
Right.
I should have highlighted that. I recommend changing the heading on those columns to the earliest likely date.
Yes.
It's conceivable that this process can move faster. and
Right.
Not by orders of magnitude, but it's conceivable it can move a little faster than this. So earliest likely date is April 2013, yeah.
Right, so would it be fair to say that it would be that period, January to April of 2013, that both applicants and communities would have to digest the regulations for Phase 2 and act accordingly, I guess, understand them and begin those negotiations? Is that, I'm just trying to highlight for communities if that's really the time frame that we're thinking about. And again, this is the earliest likely. It could slip all the way to November, which is fine.
Well, it could also advance slightly, too.
That's
I mean,
right.
That's why it's likely.
Yep, right.
Well, this is something you brought up, Commissioner Zinnig, at the first meeting.
Yes.
At the meeting last week as well.
Yes.
And you're putting something, you're sort of describing the internal workings of the process as opposed to just putting markers at the essential breakpoints, which is fine. But if what we could do would be to say, let's see, under applicant submission of completed RFA1, the second box, we could put something that says ongoing drafting and review of RFA2 regulations. It's not exactly a parallel function. The function here was just to say, what are the critical path points, not what's the process going on in between the critical path points.
Fair enough.
But you've now brought this up twice, and it wouldn't harm. If you wanted to just put some words, why don't you send us some words and we can try to put it in there?
Yep.
If the other commissioners are okay with it. It's a little bit confusing because it's not quite the same functionality, but I don't think it hurts.
I can do that, and I actually had just noted that word just in that box, that we
Okay.
needed
The
to
other
put
thing
in
was
something to
Commissioner
regulations.
McHugh had suggested that there might be a different chart, a sort of a process chart, which absolutely would include what you're now talking about. That could be amended, could be appended to this as soon as we have it.
Yep.
And I don't think he's had a chance to draft that, but maybe that's the better place to put the piece you're talking about.
The document that I was envisioning, Mr. Chairman, is one that I started on. I just haven't had a chance to finish it
Right.
yet, but it does do that, and that sort of lays out in more detail, but graphically, in a few slides, what the overall process looks like.
Which would include the point that Commissioner Zuniga is talking about.
Yes.
Yeah.
And so I'd still like to get those comments, and then we could figure out whether so I can make sure to incorporate those in that process document.
Right.
So that'd be very helpful.
Yeah, so why don't you give those to both Commissioner McHugh and to me, and if it looks like it ought to fit on here too, I'll do that, but for sure it'll fit on the Commissioner McHugh's chart.
Okay, so that's, so I'll make the revisions that we've just discussed here, and then take a look at what Commissioner Zuniga gives, and we can both take a look at that and try and get this finalized and available for the public use and public commentary. And if there's, if this document, this is like many things that we're doing, if this raises questions, and we get questions as a result of this, we can always change this to deal with those questions. The objective is to continue to make these documents as helpful as we possibly can, and we can't anticipate everything, but we can change them as we move forward. I wanted to spend a second, though, and we've referred to it a couple of times, on the protocol that we discussed at the last meeting, and I wanted to spend, and I suppose this is the appropriate space, a minute just talking about that, Mr. Chairman, and hope you'll supplement what I'm about to say. But the origin of that document was the concern that was expressed by a number of state agencies about being overwhelmed by requests for assistance, guidance, approvals, preliminary approvals, and the like by individuals who would not ultimately be bidders for a project. And there was a concern about that, and a concern about the amount of time that kind of process would take. At the same time, there was a concern that we were hearing from cities, towns, communities about how to get assistance and where to go to get assistance for their concerns at the state level. So the purpose of this document was to allay the concerns of the state agencies that had them and help and assist the communities that had concerns about where to go by creating an individual who would act as a facilitator. Every facilitator is a gatekeeper. It's, I suppose, in a sense, it's, two halves of the same coin, but not to slow the process down, but to facilitate and coordinate the process so that nobody would be overwhelmed, the fears about being overwhelmed would be reduced, and the people who were in need of help could have a single point of contact to go in order to get that help. That was the background and the genesis of this document. So the chairman, Crosby, and I went and talked to a number of the secretaries who had these concerns, and this is a protocol and a plan that evolved from that. Like everything else, it's a work in progress. Like everything else, there are some who don't need the kind of help that this provides. But this is a process broadly viewed, in which everybody ought to be on the same playing field, so that nobody ought to be left out in the cold because they don't know which room to go to and which door to knock on. And this is a document that's designed to do that, to help that, to tell people what doors to knock on and where to go, and at the same time, reduce concerns about overwhelming traffic coming in an advisory, seeking advice on hypothetical projects that may never get off the ground. It can be revised and will be revised if there are difficulties with it, but that's its origin, that's its design, that's its intent. Mr. Chairman, I don't know if you wanted to say anything more about that, or think we need to say more about it, but that's it seems to me.
No, I think that was right on, well said. I know there have been a couple of comments from, I guess, from the developer community, raising questions about the process that's laid out in this protocol. And you're now making the point that this is, we appreciate feedback. If there's ways to make it better, we'll do that. But is it worth you just giving us sort of the highlights on what those questions were, and whether that's affected your thinking at all about the way this ought to work?
Well, the specific questions, I mean, the questions that have arisen, they've come in through through our MGC comments web and site and other ways, is that some people want to get started and want to get moving and view this as something that will slow them down. And that's the essential thrust of it. And that they ought not, they shouldn't need to follow this process. And they view it as a constriction. Given the reaction of the secretaries to the initial problem, this is designed to overcome that and not slow anybody down, and designed to facilitate the interaction between the appropriate state agencies and the developers and the host communities and the surrounding communities and the like. And at the same time, make sure that nobody gets an advantage simply because they know the particular doors that they need to go knock on and other people don't in these early negotiations. I think both halves of those are important considerations, or both parts of that are important considerations. And if it appears that this is slowing somebody down to slowing somebody down to thwart progress that otherwise could be made, it seems to me that we ought to hear about that and we ought to try and fix it.
Right. Good.
So the answer is, it hasn't changed my thinking, Mr. Chairman, but it remains like everything else, plastic and designed to be helpful, not obstructive.
Great.
Any other comments or thoughts about that?
If you could fill in on the second bullet point, which section that is, then I think this is ready to go.
I'm sorry, I missed your question.
The second bullet point talks about once a developer is qualified and paid the license fee called for in section blank.
Oh, yes, I'll do that.
Thank you. So I think on these three documents together, we have a couple of edits coming on two of them, but they're pretty much ready to go. So we'll move the job description quickly through with an edit from Commissioner Stebbins to Commissioner Zuniga, and we'll finish up with Commissioner McHugh's edits and Commissioner Zuniga's edits on the advisory, and then I think we're ready to distribute all this stuff to interested parties. I don't know that we need a vote particularly on this, Mr.
No, I don't think we do either. I think because it is a policy, and we're prepared to change it if it's necessary to do so. And so, as with everything else, we welcome comments about it. There was one other comment. Let me bring up one other comment, because you mentioned it with respect to the section, which I have to fill in. And that is, there was a suggestion from somebody that they ought to be able to jump to the second bullet simply by putting down the $400,000 investigation fee before they actually filed the RFA 1. And thereby become a applicant without an application. Without a formal application, i.e. a signification of a serious interest in a project sufficient to overcome the concern that this was a hypothetical player who was just testing the waters and about something that would never happen. So that was a suggestion that was made. I don't know what the reaction of any of you, what reaction any of you have to that. That's not something that's been taken up with the secretaries, and depending on what.
I don't quite understand that. Compare that, the question you just said somebody raised, with the second sentence in the second paragraph of the protocol. What's the distinction?
The theory is that the $400,000, the statutory $400,000,
By themselves.
is to accompany the RFA 1 application. That's the way we've been envisioning things to happen thus far. And we envision things to happen that way thus far because the statute says that when the application is filed, it shall be accompanied by a $400,000 application fee to defray the costs of investigation of the application. The question is, and here this protocol says that once you have filed, once you've paid the $400,000, you move to the second stage. You've become an applicant. But embedded in that, I think, is the notion that the $400,000 accompanies at least the RFA 1 application. But it can't today because the regulations aren't out there. So the question that's been raised is, can we uncouple the $400,000 application fee from the necessity to actually file an application? We give you the $400,000. We say we have every intention of becoming an applicant. You haven't issued the regs, so we can't be an applicant. But as soon as you issue the regs, we will be an applicant. And in the meantime, we want to move forward with our planning.
That's very interesting. I'm glad you're bringing this up because I may have seen this differently from you. I didn't mean that what I thought we were talking about was when the $400,000 is paid, which would be at the time of receiving the blank RFA 1. You walk in the door, you give us a check for $400,000, we give you the RFA 1 to go fill out, and you are an applicant. I was not thinking that it would be when they complete the RFA 1, which is 3 to 6 months later. So I maybe have been thinking about it more in the way that it's been raised.
So I mean, this is an important point because I mean, that's, the regulations are going to spell this out in more detail, but we haven't gotten in some ways down to that level. So, I mean, there are a number of different ways that we could go in that, but under your view, Mr. Chairman, the $400,000 would come at the front end of the application process, i.e. when you got the blank form.
Correct.
And I think the suggestion that we're getting is that it could come even earlier. It could come tomorrow. And,
Right, well, that's a different question, but
Oh,
let's take them one at a time.
oh, I understand that.
Yeah, okay. Yes, you're right. I was thinking that we've said we hope we'll have the regs finished by October 12th.
Right.
And we would at that time be able to issue RFI A1 for interested parties.
Right.
It was at that juncture that I was envisioning bidders would pay their $400,000 and would become an applicant.
Right.
That one, I would be very comfortable with that. I think nobody's going to do that. Nobody's going to come in and get an RFA one and leave behind $400,000 if they're not very serious. Doesn't necessarily mean they will pass muster, but they believe they'll pass muster and they're very serious.
Right.
So I would be okay with that. Whether we should let them come in tomorrow with their check for $400 is a interesting idea I hadn't thought about.
I haven't thought about it either, and I don't think that certainly was never discussed when this protocol was being circulated to the various agencies.
Right. What were you envisioning as to where the 400,000 would fall? Where were you?
Well, I was just proceeding on a different reading of the statute, a different approach, interpretation, and that is that when the application, there's only there's a unified application specified in the statute, not necessarily specified, but when the application was filed, I thought, when an application was filed, I thought when the 400,000 would come. But
So that was different from what I was.
yeah, but that doesn't necessarily mean it.
Right.
It has to be that way.
Right.
I agree. That was also my understanding, or my assumption, that we would receive an application and the 400,000 at the end of that solicitation period. And, but I'm also intrigued by this notion of trying to even bring it earlier. I mean,
Let's think about what are the downsides. What's the downside?
I'm thinking in terms of what's the motivation, besides we can get to the downside in a minute, but what would motivate someone to fork over 400,000 as early as possible to continue doing their own plans? I'm really interested into why would anybody want to do that?
Because, I think, because they would like to go forward with, the people who would do that would like to go forward with the permitting process and have the access to the various state agencies that they need to engage with in order to move the permitting process forward. Not necessarily to the point of getting a permit, maybe, but at least moving forward to the point of engaging in the kinds of negotiations and discussions and planning that's necessary for any complex project, and being ready when the license comes to go on to the next stage.
But to some degree, this is something that they can do currently. I guess they would be in an official capacity, if you will. They become legitimate.
Not under this
No, this is protocol.
Right. I'm sorry, just to finish that point, so that everybody's clear. Under this protocol, prior to becoming an applicant, you get one
meeting.
Yeah.
Would this be an appropriate question for our gaming consultants to ask what has been done in other jurisdictions, and are there best practices and reasons why a process is followed, application and monies are collected? I would just think there might be some advice there.
We surely can take it up with them.
Yeah. No, I think to answer Commissioner Zuniga's question is, it's motivation is to just keep moving the process. I mean, it's speed. I want to know if the road I'm going down works right, and $400,000 seems a small amount to pay to begin to get that feedback from, the related permitting agencies.
The only complicating factor I can think of, and I'm not sure it is, but we don't yet know, we haven't even started to contemplate what degree of completion of a site preparation, we will require for either the referendum and the host and community agreements or our own application. We know there's an issue there where you have to have been permitted to broaden the highway, where you have to, whatever the environmental ways, where you actually have to have been permitted on any of this stuff, or can you leave it in a hypothetical with an advice? We just haven't worked that through, and it's a very complicated issue, as we've discussed, because if there's a referendum on a proposed highway extension, for example, and eventually the highway extension doesn't get approved, then we don't know whether we've got a referendum that counts or not. So there's a lot of subtlety to this that we haven't started to think about. Is there any reason why we would want to have our own ducks a little more in a row, give us another 60, 90, 120 days to be thinking about issues like that before we set the developers loose on the state agencies and the towns trying to push for whatever degree of specificity and completion they think is appropriate? That's really the only issue that I can think of.
Well, I think we need, having just raised this issue and having obviously determined that we have different had different views as to when the application fee was resolved, I do think we need to think about it some more. I do think we need to think about it some more. I'm not sure we need to get as far as that, Mr. Chairman, but because in the end, any requirements that we impose, it seems to me, are minimums in terms of timing. For example, if we say you have to have some kind of a permit in hand by the time you do X, that's not a prohibition on having that permit in hand much earlier.
Right.
So I think that might be the response from, so I think we need to, but I do think we need to think about this a little bit more before we and then go back to the agencies and see if they have any problem with this. This is really simply, not merely, this is in part designed to foster a collaborative and cooperative relationship between the state agencies and the cities and towns and the developers. So,
Yeah.
I have 2 points on these, 2 additional points. If we were to accept somebody becoming an applicant as early as possible, without an ombudsman, one that we are, would we be, who's supposed to coordinate those meetings, would we be a little bit behind that process only because some of those meetings start to take place in his or her absence? That's one question. And also, I think we need a little bit more infrastructure financially to accept those kinds of monies and have the financial controls in place before we do that. So I know that tomorrow, you don't really mean tomorrow, but if it's really quickly, we need to, we would need, to establish the right controls around the bank accounts and our ability to accept that kind of money.
you could just keep it in your desk.
Nope, I can just keep it in my desk, even under my, locked file.
All right.
Well, I think that's a good point. So I agree with both Commissioner McHugh and Commissioner Zuniga. We're definitely not going to decide this today. I think we'll go back to the state agencies, talk it through with them, and I think interested parties should know that we're going to give this another couple, 3 weeks consideration anyway. And so we will both clarify what was the original intent of the protocol, and we will decide whether we will be willing to move the 400,000 up even further, but give it 2-3 weeks to think about it.
All right. Anything else then on that particular topic? All right. Charitable gaming is the next item on the report. I have very little to report on that. I'm going to meet with the folks at the lottery tomorrow, personnel at the lottery, to talk about things with them. We've asked for comments on the general subject of charitable gaming from the clerks of cities and towns. We've gotten some very helpful and thoughtful comments. I've asked a number of groups of people from various segments of the legal community who represent charitable institutions to solicit comments from their members or give me their own comments. So we tried to cover the waterfront of the user community, the regulatory community, and the taxing authorities as to their thoughts, and we're on track. We continue to be on track to have a report for the legislature by the end of the month. Any questions that I can answer about that? Okay. Finance budget, Commissioner Zuniga?
Yes, very brief. Working on the budget template, I shared my current budget with our gaming consultants. They gave me some quick feedback into some of the assumptions there, but are looking at the details of that because as part of their strategic plan, there's this budget piece that they have been thinking about as well. So more feedback on that soon, and hopefully I can present a budget in the next couple of weeks to this commission for approval going forward.
All right.
That's it.
Thank you. Any questions, comments? Public information, public education and information. Why don't we go directly to Director Driscoll for a report on what's happening on that front?
Okay, good afternoon, everybody.
Good afternoon.
I'll be very brief, because as I.
Hello.
Hello, how are you? But as I told everybody, I have a series of meetings set up this week and next. I actually just added another one to the roster the other day.
Wayne, can you speak right into the mic?
Sure. And so I have a series of meetings set up this week and next. I'm looking forward, hoping this week I can get a lot of administrative work done in preparation for these meetings, which is to basically go to several companies on website development and also logo development. My plan is to have as much preparation done for those as possible to try to streamline the process. I just figured if we know exactly what it is that we want done from a company, I think that the process will move a lot more quickly. So just, I've been working closely with the Nevada Gaming Commission, who just recently completely revamped their website, and it's a great standard for what our needs will be in the future. And quite frankly, a lot of it is we can use for what we need right now. So I've just been working with them just to determine their budget, how they work with a company to develop it, what they have in terms of ownership of the site, important things like that that will matter down the line. And again, I've also been researching, just developing some sort of brand and style guide, just so that, again, down the line, we have an idea of proper logo use, and we actually have to go with, like an employee manual, what the guidelines will be for who can use the logo, how they can use it, what's an improper use of a logo, things like that. And then Speakers Bureau criteria, I'm in the process of just building a target list of the first round of speaking engagements. I'll have a memo for everybody next week on, what I propose the criteria be, and what some of the language, legal language should be in that as well. And then again, hopefully with the development of the website and the logo, we'll be able to also develop a really strong PowerPoint and possible video, basically to take on the speaking engagement schedule across the state. And then also, hopefully this week, I'll get to the communication section of the employee manual. I plan to get to that this week as well.
Sounds entirely ambitious. Sounds
We're
great.
getting there.
Maybe, well, excuse me, if nobody else had anything, Commissioner McHugh, I wanted to bring up the issue that Director Driscoll had raised about the inquiry from a party, and we were going to have a discussion about how we would handle such meetings when interested parties wanted to talk to us. Is now the time to...
Yeah, yes, Mr. Chairman, I think this is a good, good time to bring up that idea.
Okay. Well, Director Driscoll got a contact from some party, I think, working with one of the tribes in southeastern Mass, saying that they were working with surrounding communities. This is the consultant who's working, I'm not sure who they're retained by, but working with surrounding communities, and they had some suggestions for us on how we might deal with and support surrounding communities. And they wanted to speak to one or more of us to talk about that. So that caused us to think about what's the proper protocol here. And I think our sort of prima facie reaction was maybe it's not a bad idea. There are going to increasingly have people who around, but even participants, who have constructive suggestions to make about the process, and maybe we should invite them to do it either in writing if they wish, or to come into one of our regular meetings. We could set aside a half an hour or something each day, each meeting, where people who had not proposal-specific things to talk about, but general things to talk about, they could come in and do that. That leaves open the question about how do we respond to inquiries, which will surely be coming soon, that are proposal-specific, and where a proposer wants to talk with us, just like they want to talk to state agencies about how's the process going to work, questions they might have. They might want to consider those discussions proprietary and private. And so I think we've decided we needed to talk about that kind of meeting as well. So there's the two kinds of meetings on the table with interested parties, basically proposers and their affiliates.
Yes, those are on the table, and it seems to me that we have to think through the ramifications of that carefully and articulate a policy at the least, perhaps a part of our regulations. But above all, we have to maintain a strong atmosphere of transparency. I mean, that has to be, it seems to me, the overriding consideration in how we formulate a policy to deal with this.
Right. Even-handedness and transparency.
Even-handedness with respect to access, and even-handedness with respect to discussions. And to the extent there is something that is truly proprietary, a trade secret that somebody has to discuss with us, we can figure out how to deal with that. But we need to craft regulations that in the main say that the interactions are open and transparent. I think that's a default. We need to think it through. So, but it seems to me that's the default. Other thought? I mean, this is coming out of sort of suddenly. But is any other thoughts or instinctive reactions about that?
Yeah, my thought is one of, first of all, having discussions around this, and then ideally crafting regulations to that effect, to the extent that it's timely, and whether they fit in some of our phase 1 and phase 2, that's a separate or a minor matter, but that's my reaction.
Well, it seems to me the sooner we get a grip on this, the better, because these discussions and requests are, a couple of them, or one of them actually has already come, and they're likely to start coming. Is that something that would go in a communications policy logically, or is it better left outside of a communications policy and done separately?
I mean, my sense is that, I think where the communications aspect of it comes in is just making sure that in my outreach, I'm keeping everybody informed of what the expectation is in terms of the parameters of interaction. But the actual setting up of those parameters, I'm not sure that that comes under a communications policy. I mean, the one thing I think about this, though, as well, is through our open lines of communication with the Ethics Commission, I think that one of the things that they were making a point of is the fact that we are on a fact-finding mission at this point, so that there is the ability to engage in discussions that will ultimately help us to be more informed as we're drafting these regulations. So that's just my 2 cents on where I think we are, but.
We cannot have been the first people to encounter these issues, and this too is an area where our gaming consultants may have some helpful information for us, and where the public, where there may be regulations in other jurisdictions that deal with this with this precise issue. So it probably would be good to check with those. And with respect to pending requests, simply have a default that we'll talk to anybody in a public session until we get the regulations and policy fully developed. Mr. Chairman, what do you think about that approach?
I basically like that approach. I think we will probably start getting a lot of requests to come to our meetings, but
That's good.
but that's fine. Yeah, I mean, I don't think, why not? So this party that wrote Elaine, if they want to come in, if they feel that adds something more than just sending us a note, then we let them come in. And I agree with you. Then we won't. So we have no private meetings unless and until we work out a policy to do so.
Is everybody comfortable with that?
Yep.
Makes sense.
I mean, we don't need to have a vote on that. That's, again, just a policy that we're going to
Right.
adopt, and Elaine, you can be cognizant of that if you get requests, and that's the way we'll proceed. Okay, thank you.
Okay, thank you.
Speaking engagements is the next one. Chairman Crosby, did you want to say anything about that?
Well, we followed up on the meeting last week where we discussed the fact that State Representative Laurel had asked for this meeting, and we clarified with her and through her to the folks who wanted to get together that we will not be able to give very much in the way of specific data. We couldn't do it on a commercial license, never mind we can't do it for a tribal license. But having said that, we are more than happy to get together and meet with people and to hear their concerns. And they responded, Rep. Laurel and her constituents responded very, very favorably to that, and we're pleased that we were willing to do it. So I'm meeting with them, I think it's next week. They happen to be halfway between here and Boston, so I can combine it with fresh air. But I think we should make sure that reps and senators all know. People frequently will come to them, their towns will come to them, thinking that they are the repository of all knowledge, and we should offer our services to meet with their constituents if and as they want, and we can parcel it out amongst the five of us.
Yes, and those would be all public meetings, and
Right.
people can attend them and see what's being discussed, and a good way to get information out to everybody. Anybody can come to it. Okay, discussion of the Western Massachusetts Forum. Commissioner Stebbins, anything new to report there?
Sure, no, the only, two quick updates to that. I spoke with State Senator Canderas on Friday afternoon. Again, she has offered up Western New England University to host our forum, similar to, I think we had a state senator speak at our mitigation forum out in Framingham. She's had a long partnership with the university and was happy to be the go-between between the commission and the Pioneer Valley Planning Commission, which is also helping to develop the agenda for this. Also had the occasion the end of last week to speak with the ad firm that has been hired by the Mass Office of Travel and Tourism to do advertising, and they're planning to speak at the forum with respect to the topic of tourism, thinking about how Massachusetts now will need to kind of rebrand itself when it comes to blending in casino gaming as part of a tourism strategy. I shared with the gentleman information about, since we're breaking it out by regions, how each region will, consider, I think, different tourism strategies and marketing strategies differently based on the assets that are there and how casino gaming will fold into that. And so the head of that firm is going to be one of our speakers at the forum in Western Massachusetts as well. Hopefully we'll have a date nailed down either the end of this week or early next week.
Great. Sounds terrific. Any questions, comments, other thoughts? Okay. The research agenda, again, did you have anything more that you wanted to report on that, Commissioner Stebbins?
Sure. I've taken the, Chairman Crosby did kind of the inventory of kind of research topics that we want to have considered in some of our baseline research. I've shared that out with folks that spoke at our Economic Development Forum in Worcester earlier this month, waiting for some feedback from them. Also, two speakers that I had hoped to have at our forum in June in Worcester are willing to make themselves available to come in and talk to the commission at our meeting on the 17th. Richard McGowan, who's from Boston College, and Professor Robert Goodman he's retired, but he was previously at UMass and Hampshire College out in Western Mass. He also has an interesting background because he has, I believe, a degree from MIT in architecture. We can ask him about the architecture and design issue with respect to gaming facilities as well. So those two gentlemen will be here to give us their thoughts on a research agenda as well at the meeting on the 17th.
That's terrific.
I had a couple of things I wanted to add too. First of all, I did want to check with the governor's office, who is my appointing authority, and with the Ethics Commission to see whether there was any problem with my being involved in the possible procurement of a research unit, since one possible bidder or one possible doer of the work might be folks from UMass. And both the governor's office and the Ethics Commission thought that through and made it clear that for a variety of reasons there's not a problem with that at all, which is good because I'm anxious to be involved in this. But the point that Commissioner Stebbins and I talked about last week and wanted to bring up specifically this week is the following. We're talking about the possibility of a very, very big research project. Big in terms of its comprehensiveness and its scope and its potential impact for understanding the impacts of socioeconomic impacts of gambling, but also big in terms of cost. And he and I are thinking that we're going to ask somebody to help us scope out what such a study might look like. And we're thinking that it might well be worth putting out some kind of money in a planning grant, in a small planning grant, so we can get people to really think hard about this without having to do it on nights and weekends and scraping from Peter to pay Paul to pay for it. Lots of times, big organizations, when they are big funders, when they want to have a very big project done, put a very small amount of money into a seed funding in advance. So I don't have any idea what that might be in terms of scope, amount of money, but if my proposal, and I think Commissioner Stebbins agrees with this, proposal would be that that the commission authorize me and whoever I work with, to scope out a planning grant proposal, as well as think through the procurement process, both for the planning grant and maybe for the whole research project, and with a presumption that we would be willing to fund a planning grant, and then bring that back to a commission vote in whatever, a week or 2 or 3, however long it takes. Is that accurate from your standpoint, Commissioner Stebbins?
Yes, it is.
I have a question. How are we envisioning this planning grant or who are we envisioning this planning grant would go to? To a group of individuals working collaboratively so that they can outline a scope of work that will guide our research agenda? Is that the thought process? Or could this go to whomever wants to eventually respond to our solicitation for research, for the big research project, so that they can themselves work on whatever needs to be done?
What was that second option? I didn't understand that second option.
So who would this grant go to? One group or multiple groups?
Okay. Well, it's not decided. That's what we're here to talk about. Here's what my thought process has been is this. There is a research group at UMass Amherst that has been following our work for a long time. They've sent us Rachel Goldberg. You've seen a lot of her stuff. She's one of the, by any measure, she's one of the most well thought of gambling researchers in the world. And they've already come to us and made the proposal that Commissioner Stebbins and I gave to you, and we said to them, that's just focused on problem gambling. We really want to take a bigger look. And we said to them, would you be willing to think about how to scope this out? And they said they would. It's a team of people. They've got people presumptively from not only other UMass campuses, but also from Harvard and MIT, and they are pulling together a team of the best researchers in this business in basically in the world, I think. So we've said to them that we'd like to have them think about this, and that we would look into the planning grant idea, but we were clear that there were no commitments, there were no promises. We also said we might possibly have to put this whole project out to bid at some point, so they would be working on spec to some extent. But if, in a perfect world, if it fits within all the rules and appropriate policies, my inclination would be to give this group the planning grant, headed up by this Rachel Goldberg, and then we would be talking about, once we get a scope, they would then put together a scope. We would eventually decide on what scope we want, and then we would decide how to procure that project, whether we would go ahead and do it with them, they're another state, UMass is another state agency, or whether we would put it out to bid or whatever. That would be the process that I would propose, but I don't know if that works for everybody else.
Well, what we may be touching on here is that whoever might help us scope out the scope of work to do is clearly in the best position to respond and do that scope of work, potentially. So we need to think through how we select the group of people who is going to help us write the scope. Now, I recognize, however, that there's a limited universe of people who could do this. But because there's this nexus after this period, we just need to think through that.
I agree with that, and I think if I just don't know how that cuts, and that's one of the issues that I was hoping that you would empower us to look into and figure out, and I would talk about that with you, Commissioner Zuniga. I think if this were XYZ for-profit company, just some company somewhere, I probably would feel differently about this. agree with you that that's something we need to think through and maybe talk about with the procurement people and so forth.
Yeah, no, they're not profit-driven, but there is a real significant cost component that we just need to think through. But
Right.
I can also make inquiries of the Inspector General relative to procedures, so just to educate myself on these kinds of options or eventualities.
And I think we may find ourselves in a position when we move to the larger scope of the project, we'll get more inquiries, and similar to how we kind of made a marriage from Michael and Carol and Spectrum, we may be able to find people better attuned to doing one piece of the research coupled with an application or a project proposal from somebody else who, may
Right.
have the problem gambling piece well in hand, so.
Right.
And maybe I'm stating the obvious, but because there's large variability in how we approach this, if we go one route or another, that could include or exclude certain groups depending on how we swing. And
Right.
that's the gist of having to discuss this.
I didn't follow that, I'm sorry.
Because the research agenda could vary very widely in how we ultimately, the detail, and cost and tasks that we may end up doing at this stage of the game, it could be very variable, really. It could vary widely. So the decisions that we make relative to listing a scope of work early on may end up excluding or including groups that respond to that solicitation later on. And that's why it's important to have those discussions.
Yeah.
I agree.
Okay.
So what's the next step there? Do we need, is there an action item for today, or is there simply a consensus that we should go forward with the contemplation of a proposal for a planning grant enough?
If that's okay, if everybody is presumptively okay with the idea, then I think I would just to agree would be fine, and then I'll try to take it to the next step, and there would be nothing. I work on both the issues that are involved in procurement with Commissioner Zuniga, and work with at least this one group on teaming up a grant, scope, amount, and then come back to the commission with a proposal.
Sounds
That's fine.
sounds
Makes
fine,
sense.
and
Sounds fine.
everybody seems very happy with that, Mr. Chairman.
Okay.
All right. That brings us to other business.
Yeah, I have one. I saw, as I'm sure everybody did, the paper this morning where one of the Eastern Mass proposers talked confidently about their proposal, which is fine. But it concerned me that there may be an impression that there won't be much competition in Eastern Mass. And that is a perception which I think is not in the public interest. And I wonder whether it would be a good idea somehow or other for the commission to make some kind of a statement about the importance of competition and to encourage competition, or words to that effect. This was something which obviously didn't come up until today's newspaper, so it couldn't be on the agenda formally. But I wanted to bring it up and see if other folks reacted the way I did, and if there's any way we can do anything about that.
Well, I didn't react to specifics, but the notion that competition is in the public interest, I think, is a foundation of our republic. And it certainly is a part of what it seems to me is likely to enhance the legislative objectives in this bill. One of those objectives, of course, is job creation, competitive proposals where various people are attempting to demonstrate how and by what method they can create Massachusetts jobs. Inevitably, it seems to me, leads to the likelihood that a job-enhancing proposal of the best order is going to be produced. Revenue enhancement's another legislative goal, and the same is true there. Trying to promote tourism, competition in how to design a facility to attract people to come and enjoy the benefits of this marvelous Commonwealth is likely to lead to proposals that amplify the likelihood that we're going to get tourists to come in and bring both their interest and money to not only to the casinos, but to the other amenities that surround the proposals. And mitigation is another clear legislative objective. And regardless of what proposal is ultimately selected, where a license actually goes, the ability to look at multiple proposals and pick from them things that might become conditions of a license in the prevailing proposal is a worthwhile undertaking. These proposals are going to come from highly talented, thoughtful developers, and the more of them we have seeking the ultimate license, it seems to me, ultimately, the better off we are. So I'm not sure what this commission can do about enhancing competition any place, except to acknowledge and say that a competitive environment is one that the commission views as one in which that the statute was designed to foster, and that this commission is very interested in helping to promote.
I have, I agree with everything you've said, and I have a thought relative to schedule that I'm really looking forward as we evaluate scenarios with the help of the project management firm that we just talked about earlier. And that is, if this commission were to bid out the first region, the one that's most competitive, first, thereby allowing potential runners-up for that region to make a bid or a move on another region, is something that I'd really like to understand from all the moving pieces relative to schedule and timeline. Now, something tells me that these proposals are very site-specific and site-driven, and there's a big local process that that we all know about. But the Spectrum report from 2008 suggested bidding out the most valuable license first, not the most competitive necessarily. But the thought was that this staggered bidding could elicit those who run up, who didn't get the license, an opportunity, at least in theory, to move for a subsequent license. So that, in my mind, is something that we need to explore. It has huge time implications. It has huge implications relative to process and investigations. But that's one of the pieces that I'd like to see from our project management firm as they start scheduling scenarios for us.
I think that's a really good point, and we've sort of mentioned that in passing before, and I agree with you, and I think it's right in. I do agree with you that even considering it carefully is one way to do what Commissioner McHugh is talking about, which is to tell the world that this commission believes that competition is really important and believes that competition will maximize the potential for the Commonwealth to get out of this process what it has wanted. So I very much agree with you, Commissioner, that we should consider that phasing issue, that phasing strategy. We definitely would not consider it lightly, but I think it's definitely one we want to consider. But I also think that it might make sense just because of the timeliness of this recent article, if we issue just some kind of a statement that says basically what Commissioner McHugh said, that puts the commission formally on record saying that we believe that competition is in the public interest and competition will maximize the potential to get the return that the Commonwealth wishes, and that we encourage it, or words to that effect.
I echo what Commissioner McHugh said, and interested in Commissioner Zuniga's comments. I mean, obviously, the legislation spells out pretty clearly what we essentially look for in an application under Section 18. It looks for a number of things related to broad goals of revenue and job impact, but also project specific. So as much as we want to drive competition, we're also trying to drive quality in those applications to allow us to render a decision on a license and base it on a lot of those qualifiers that the legislation outlines. So it's all a piece of the puzzle, but the more the merrier.
Right.
Yep, I certainly agree with everything Commissioner McHugh had to say, and Mr. Chair. I'm just a little concerned about how we would make decisions on one region going before the other without being extremely problematic. I just can't envision how that would happen without someone claiming that they were disadvantaged and making another region wait to move forward with a project or a proposed project.
Well, just for the record, I'm a long way from thinking that that's what we should do. I just think that it's a legitimate point. Particularly, right now, if you look at Western Mass, for example, we've got a whole bunch of bidders. And maybe those folks would be interested in another site if they knew they weren't going to get Western Mass. And I have no idea. It clearly would be a very controversial and difficult process to entertain, but I think it's worth thinking about, that's all. But I'm certainly a long way from thinking we should do it.
Yeah, I think it's way too early to think about staggering or that kind of process. And I'm not sure that we can do much more at this moment, but I do think it's important to do at this moment a statement of some kind, and maybe what we've just said is enough. Maybe we ought to do something else. But to underscore the belief and the principle that a competitive process is a desirable social good for implementing this legislation as it is for many things. And that the Commission's view is that competition is a healthy ingredient of the process we're trying to move forward.
There's a second point to it, just again, sort of for the record, we are not mandated to do one per region. We're mandated to do up to one per region, and we're going to be looking for proposals that do what the Commonwealth wants done. And if we don't have very many options to choose from, then maybe somebody runs the risk, a region runs the risk of not having anything. So for all the reasons, it's in everybody's interest, I think, to have as much competition as possible. So I agree with the Commissioner.
All right, anything else we need to, and we're a long way from that, too. Anything else anybody wants to offer by way of commentary on that? All right. Is there any other business? All right. I'll entertain then a motion to adjourn.
I make a motion that we adjourn this meeting.
Is there a second to that?
Second.
Commissioner Stebbins, how do you vote on that?
Aye.
Commissioner Cameron?
Aye.
Commissioner Zuniga?
Aye.
Mr. Chairman?
Back to the beach.
Aye as well. Now, Mr. Chairman, we had no difficulty hearing you at any point during this meeting. I take it that with the exception of the few times when you interjected to ask for somebody to repeat, you had no trouble hearing us. Is that so?
The link from the guest's chair did not work very well, but otherwise this worked extraordinarily well. I mean, it's by far the best conference participation I've ever had, both the sound and being able to watch the commission as it's meeting. It worked amazingly well.
All right, and you were able to understand, though, that the substance and content of what Ms. O'Toole and Director Driscoll had to say, I take it.
I was.
Okay. All right, we're adjourned. Thank you very much.
Thank you, everybody.